Do all wills go through probate? The answer is no. Not all wills have to be probated, meaning that not all wills have to be taken to the court and run through the probate process in order to administer the estate of a person. So who determines if a will has to be probated or not? It's not necessarily a who, I think it's more of a what. What does that mean? Well, probate is usually triggered by several things. I am going to address two main ones today. So just because a person passed doesn't mean a probate has to be filed, and that's when the will have to be used in the probate case. The two main things that trigger probate is real property. So if the person who passed and had a will has real property, such as a home, land, mineral interest, and they only have the will, no trust, no other estate plan in place, the chances are that their estate has to be probated, meaning that the will have to be filed with the courts and run through the probate process. An attorney can help you determine if the property is indeed in a person's name, and they can check to see if there is an estate plan based on what's filed in the county records. But ideally, you have this information in place. You look around and try and locate a will, a trust, transfer on death deed, and so on. So number one, real property. If there is no one else on the deed as a joint tenant, or if the person on the deed also is deceased, predeceased, then the chances are you'll have to use the will. The second one is financial accounts without beneficiaries. Basically, if let's say there is an investment account out there that has $100,000 in it and it does not have beneficiaries, that company is not going to know who to pay. They're not going to research and see if the deceased had any kids or a spouse. They're going to say, you file for probate and I am going to pay the money through the court system and let the attorneys and everyone else figure out who gets what. That's when a will come in handy through the probate process. If the will is valid, the courts and the system will administer the estate according to the terms of the will. So again, have an estate plan in place. If you have real property, get a trust, transfer on death deed, have something in writing. Otherwise, your family will have to probate, and that's when the will have to be used. And this is very easy. Make sure you have beneficiaries on all your accounts, not just primary, but alternate or secondary, contingent, alternate, because if something happens to your primary beneficiary, it'll go down to your second choice, so you don't have to worry about changing it all the time. It is good practice to check on your beneficiaries at least once a year during enrollment period, or pick a date and work on that to make sure they stay current. There are other reasons why probate is needed, why a will have to be used. For example, if the deceased has a minor child, there may be a minor child guardianship clause in there. Even if they don't have a home or real property and they have beneficiaries on all accounts, maybe the will be presented to the courts for that minor guardianship proceeding. As a quick summary, not all wills go through probate. If you have a loved one who passed and they have a will and you are the executor, even if you're not, be sure to see an attorney to get some guidance on what to do and take it from there. It'll basically be based on what kind of property the deceased person had and what's their situation in life, debts, assets, and so on. I hope this video helped. Be sure to subscribe to our YouTube channel, watch our other many educational videos. Give us a call, 405-857-8231. We offer free probate consultations over the phone, meaning that we can help answer some of the questions, at least to get you started, to get you thinking, and better prepared. Thank you for watching.